Yeah, is there a loser in the room today? Because if so, you're at a 10. We need you at a 5, okay? Y'all, Sarah Boone's latest motion hearings was a nightmare, and we're going to talk about some of the motions in today's video. Hello, Sofa Squad, and welcome back to the sofa. My name's Paul. That's the sofa. It's back there. If you're new to the channel, well, we do welcome you. If you are a regular watcher, well, I do welcome you back. You will notice that the new little puppies, they are not here right now. They are being babysat elsewhere, but Rosco, of course, is here in spirit. Now, y'all, today, what we're going to be doing, this is a little bit different because this is literally next level. This is what we've come to expect in this case. And the case that I'm talking about is Sarah Boone. This is the woman who's been incarcerated in county jail for, 5+ years now. She has been accused of taking the life of her then boyfriend, George, by getting him in a suitcase and allowing him to suffocate. So there was a motion hearing. Trial is approaching October 7th. This was on September 27th. And, you know, there's a lot of stuff going on in Florida. And let me just say before we even get into this, if you have been affected or not affected, if you're in the pathway, if your loved ones, whatever, my heart goes out to you. The images that I'm seeing coming out of Florida and the North Carolina mountains here, it gives me goosebumps, are life-altering, life-changing, devastating, and there's nothing to really say about it. It's absolutely horrible, and my heart breaks for you. My prayers go out for you. I hope that you and your loved ones are okay making it through this. So as you can imagine, the court systems were a little bit, you know, whatever. So Sarah's attorney was via Zoom, whatever, and clearly is not great on the technology thing. We saw this during COVID where so many cases did this and people just could not figure out Zoom and things of this nature. It is what it is. I'm not that technologically savvy, however you say that, but it started off with that of her lawyer coming in, you know, can you hear me, can you hear me, can you hear me? Then other people not muting their things, and literally when the judge came in there and said, if there's somebody in here by the name of Lou, sir, we need you to mute your mic. I was like, I am done with this case, okay? I just cannot anymore, right? It is what it is, okay? So what I want to do for the video is actually look at the motions that they went over and just go over some of them. The biggest one here, well, there's two big ones, right? There's the let's get petty fun one, which is the glam squad one, I call it, which is her hair and makeup request. Then there's also the more serious one, them trying to suppress that 2-hour interview. This is already coming, you know, not come and gone, but this has already been brought up, right? So it's going to continue on. What I want to do is just put the motions up on the screen, read through them, see what they say. They're going to be coming back to court, I believe, on the October 7th. So, October 2nd to continue following up. Trial starts on the 7th. Y'all, today I'm recording this the 29th, okay? You're probably watching this on the 30th, maybe, Monday the 30th. That's how close this is, right? And this is the level that we're still at, okay? So what we're going to do, we'll put a motion up. You can either listen to me read through it, the highlights that I'm going to talk about, or you can pause to read it. Whatever makes you comfy. Whatever makes you comfy, but either way, here we go. So what we're going to do is we're going to start off with this. It's called, with the name of it, whatever, State's Preliminary Objections to Defendant's Amended Exhibit List. Now again, if you are new here, understand that I'm not a lawyer, I'm not an attorney, I'm not a cop, I'm not any of that fancy credentialed stuff. Okay. The only credentials I got are a sofa and some sass, right? So just know these are my opinions. I'm just reading public information and going over it. I'm not trying to give law advice. I'm not trying to give any of that kind of stuff, right? So do with that what you will, but let's go ahead and look at the first couple of pages of this motion. So you see at the top it says State's Preliminary Objections to Defendant's Amended Exhibit List. Comes now, State of Florida, whatever. September 26, 2024, 7:21 p.m. the state received an amended exhibit list from the defendant. This is outside the scope of the time frame the defendant was allowed to list exhibits, but the court granted leeway for a potential extension, they say in italics. The potential, in italics, admissibility of battered spouse evidence has changed the feasibility of all of the court's deadlines in its scheduling order from August 5th, 2024. It says items 1 through 3, which the defendant did not even have yet, will likely require hearsay relevance and 90.403 objections to be made, resulting in either their exclusion or voluminous reaction redactions to be made. Also, these records may require the battered spouse syndrome experts to have to re-examine the defendant and potentially be redeposed. Okay, let's go down here a little bit. Items 4 through 7 are police reports. Police reports are inadmissible hearsay in Florida. Burgess versus State. It's unclear whether the defendant believes she can use these reports in her case in chief or for potential rebuttal. The latter may provide some limited admissibility. Reliance on inadmissible evidence by experts is permissible, but it does not make the inadmissible evidence admissible. There's a lot of the admissible word in there. I'm like, which way are we going? Okay, so it says regarding 8 through 11, the state notifies the defendant that it will potentially use photographs of George Torres's injuries as well. This will also involve the testimony of the deputies who observed George Torres and injuries during these prior incidents. That's going to be very interesting evidence. It says item 12 includes inadmissible hearsay. Item 13, inadmissible character evidence. If the defendant does not testify that she used justifiable deadly force against George on the evening she killed him, she is permitted to testify to prior acts of violence committed by George that she was aware of. This, however, does not allow a rap sheet to be admitted into evidence. Item 14 is another police report, which is inadmissible as explained above. Let's pause for a second so you can see, all these years, you're seeing what it is she's been wanting to do, right? My guess is this, okay? This new attorney that she has, Owen, and his little team he put together, they are basically going to her and being like, well, let me rephrase this. Before I even say that, let's preface it with this. In this hearing, he's like, well, I need to check with Sarah. I need to check with my client. I need to do this. So having said that, what I think is going on is he is literally going to her and saying, write down your wish list. What do you want the court to know about this case? And she's going down and all this stuff that other attorneys were probably like, that's not going to happen. That's not even a thing because of ABC. That she was like, you can't tell me different. I read a Google article. I know more than you with years of practice, right? This is just her personality type. So this attorney is going up and just going down the checklist. So that's why I think we're seeing this stuff here. Now, I'm not an attorney, obviously, but some of the stuff that comes up here to me almost seems like this seems like real simple, like not complicated, like real obvious, I guess you could say. So the way the way the state is going down is checking off, this is inadmissible because of this, you can't do this because of this. This seems like something that Sarah herself would do, not knowing the law, not another attorney who's been practicing law for a while. You see what I'm saying with that? So again, it is what it is, right? If Owen is allowing her this opportunity to just get it all out there, well then so be it. At least she can sit here and say, I finally got someone to listen to me, even though I don't think it's going to end in the way that she wants it to end. Okay, let's keep going. So it says item 15, we're down at number 10 here, is inadmissible character evidence. The attacks on the descendant's character in a self-defense case are limited to reputation for violence evidence and specific acts of violence in which the descendant committed that the defendant was aware of. Item 16 is irrelevant and likely filled with hearsay. State has not provided this information. 17 and 18 are irrelevant and inadmissible. Then it goes into item 19, A through O are inadmissible hearsay. In the 911 calls the undersigned has heard from June 18th, 2009 and September 4th, 2019. And I'm sorry, the first one was June 18th, 2019 and September 4th, 2019. The defendant makes it clear to the dispatcher that it is not an emergency. I mean, this is the thing. And these statements are not excited utterances. They are merely inadmissible self-serving hearsay. The remainder of the calls were not potentially relevant to this case until the defendant alleged the relevance of battered spouse syndrome evidence and have not been reviewed by the state. And number 14 says, item 20 does not appear to be relevant other than showing that the defendant had no injuries. 15, unless otherwise noted below, the state does not have any preliminary objections at this time to items 21 through 51 without waiving any potential objections as the trial develops, and not waiving the predicate for a photograph/movie being required prior to these items being admitted into evidence. Then number 16 says it's irrelevant, 17 duplicative, 14 irrelevant, 19 duplicative, 20 and 21 are inadmissible hearsay. So now again, I'll say this. For her defense attorney, I'll say it 100 million times in this case. Of course, anybody is going to want their person, their defense, to throw anything they can to try and get them out of trouble. This is just human nature, right? This is just you're trying to survive, okay? I get it, okay? She's fortunate enough for herself and her situation that she found a dude willing to do it. You know, she went through all these lawyers, but as you see, there's this. Now, obviously, I have a bias in this. Number one, like I said, I'm not an attorney. Number two, I think she did, I think she's guilty of this, right? I think she took this man's life. I think she's responsible for George being dead. So you can't get around that. I also think she's dragging it out. She's manipulating the court system and abusing the judicial system. And this attorney is just letting it go, because I can almost assure you, my psychic sofa abilities here, if he went against this stuff, she would have already fired him. She would have already fired this man, y'all. I have zero doubts about that, okay? So let's go on to the next little motion here. I'm just going to put it on the screen and just enlarge it, and it says state's response to defendant's objections to plaintiff's exhibit list. The comes now statement. April 13th, 2020, the court entered a uniform order setting pretrial conference and trial. Part 1, 4, and B requires the parties to file all pretrial motions 10 days prior to pretrial conference, and cautions that late filings of motions to suppress may result in denial without hearing. And they list the case law. This is very interesting to me. The defendant has had copies of statements she made to law enforcement for over 4 years. Amen. I mean, a very tiny amount of that time they sat in a box in her cell or wherever they were at the moment, and then she didn't even bother looking at them. Now at 11:43 p.m. on September 26, 2024, the evening after which her pretrial conference was scheduled, files a legally insufficient motion to suppress her statements made to Deputy Rodriguez and the first of 2 statements made to Detective Lowen, or Copesol and Lowen. Florida Rule of Criminal Procedure. This comes on the heels of another delinquent and legally insufficient motion to suppress statements filed on September 24th, 2026, 2 days prior to pretrial conference. And then it goes on further on the second page here. It says, it is unclear why these statements were not made a part of the motion to suppress filed on September 24, 2024. It says, the last thing, the court should require the defendant to file a proper motion to suppress so the state can enjoy a pretrial ruling on the motion and the jury does not have its time needlessly wasted. I mean, there you go, right? That's just the crux of this. Again, not having a legal background except for what we watch here. I mean, this is the thing. They've come into the last minute. They're filing all this stuff, and the judge has made it very clear, look, this is not going to be a reason to stall things up or do this or do that or whatever. You know, but this has been the tactic. You know, when Owen has come in at the last minute, and while I do think it's probably necessary at this point for her to have somebody, he's come in at the last minute, and it's a continued nightmare, right? You know the judge and the state are like, get this case out of my courtroom, right? Just get this, go, be gone, done, okay? What we're going to do in this one is we're going to go ahead and do that, the suppress motion. It's a larger one. Then we'll get to the good one last, the glam squad motion, I call it. Okay, here we go. Now, let me just blow this up here on my screen. So it says state's motion to strike defendant's motion to suppress statement at OXO, we'll call it, and state's response to defendant's motion to suppress statements at OXO. Now it starts off, it comes in hot and heavy. Number 1, the defendant's motion is legally insufficient. The defendant recites allegations of facts, but not why any particular fact or facts is an issue. The reasons for suppression as required by Florida criminal procedure is a boilerplate assertion that it violated the United States Constitution and the Florida Constitution. This is no different than stating a search was performed illegally and improperly and unlawfully. Now we'll skip this little case all they recite and our cite. The defendant has not cited even a single case that authorizes the court to grant her relief she is requesting. The state is left in the dark about what specific issue or issues the defendant is claiming and what legal authority there might be for the court to grant the relief she requests. So number 2 says, the state objects to any additional claims being raised at the hearing that were not specifically pled in the defendant's motion. In paragraphs 5 and 6 of her motion, she alleges that she was detained for 14 hours, and during this time she provided a statement to law enforcement. She does not challenge the admissibility of this statement. Paragraphs 7 and 8 of the defendant's motion allege that law enforcement asked for the defendant to turn over her phone and that she provided the means to unlock it to law enforcement. And then it says, Bell versus State is informative on this issue if it's the defendant's position that this somehow rendered her statement the following day involuntary. Number 5, Bell makes it clear that the police having seized evidence from a suspect and the suspect knowing they have seized evidence from her only goes toward the analysis as whether a future interrogation is custodial, not whether a future statement is involuntary. Because Miranda warnings were provided at the beginning of the interview the following day, this is not a relevant factor for the court to consider. It says 6, Bell is also informative on the distinction between a Miranda violation and an involuntary statement, which will be discussed below. I mean, this is interesting where you're trying to dot your I's and cross your T's. And again, this is where I feel like even though it's great A for effort type situation on her attorney's part, they don't seem to be coming with the proper receipts, if you will, to prove this is why this is. Because, and again, any of us would be well, I don't care, try to get it thrown out anyways, you never know. I get it, right? But it's painting a picture of what her former attorneys went through. Okay, let's keep going. Paragraphs 9 through 11 of the defendant's motion imply that law enforcement was being deceptive in their manner of summoning her for an interview she did not know she was going to occur. Pursuant to Bell, this goes to one of the Ramirez factors in deciding whether Miranda rights were required, not whether a statement is involuntary. Now we're going to go on to the next page, number 8. This is different from the deception that would lead to an involuntary statement. The defendant received no promises of hope, leniency, or misrepresentations about the law. Both the United States Supreme Court and the Florida Supreme Court have held that deception alone does not negate voluntariness. This includes misrepresenting a co-defendant's statement, false suggestions that law enforcement could arrange a satellite system to put a defendant at the scene, exaggerating the amount of DNA evidence against a suspect, informing a suspect that law enforcement was investigating a missing person case rather than a homicide, writing DNA evidence on a whiteboard in an interview room prior to any DNA analysis being performed, and false representations of physical evidence that did not exist. Now this part's interesting here because when you see some of this stuff and you see what cops have to do, and a lot of times this does come up where, especially in these interrogations for these major crimes, but this takes place across the board, where they're going to say whatever they feel they need to say to get information, right? And oftentimes when it does, say when it's involving a victim, a child, someone like that, it's almost do what you got to do, right? But you can see how with the law they're able to go in here and take this apart bit by bit. Now again, this is why people like Sarah, in my opinion, non-professional opinion, will go in and try and just rake through their stuff, because to the lay person it's well, you never know, right? I mean, they forgot to say this in the Miranda rights. Maybe, this, I didn't know that I was doing this. However, again, video is not Sarah's friend, right? When you go back and watch, honestly, any of the video of her, I'm just thinking years of this body cam footage. I'm that's all I can think of with her. Video is not this woman's friend, okay? She needs to stay far away from video. It just gets her into trouble. She went into that interview with a damn list, right? And whether she thinks she's just coming to get her phone, whatever, she had this list. She was ready to talk. She wanted to ask questions. She wanted to do this or that. So to act what's going on? It's you showed up with a list, so you're planning on talking to them. You know what I'm saying? It's almost you can't have it both ways. Going on to number 9, this is luring the defendant to the sheriff's office under the guise of returning her phone to her. If that is in fact what happened, does not make the statement involuntary. It only goes toward whether Miranda rights should have been read, and it was. Thank you. Can we get a damn mic drop on number 9? 10. Paragraphs 12 and 13 also only go toward the first Ramirez factor as to whether Miranda should have been read to the defendant. She was led upstairs to one of the interview rooms in the sheriff's office by Detective Lowen, where an interrogation ensued, after Miranda was read to the defendant. 11. Nor is there coercion. Although the defendant has not specifically made that claim or cited authority, Martin v. State, allegations that law enforcement 1. Threatened the suspect with the death penalty, 2. Deluded the suspect as to what he could expect for himself from a jury if he confessed, 3. Deceived the suspect as to the amount of time he had to cooperate with law enforcement, 4. Promised their favorable testimony and use of their influence during his trial if cooperated. 5. Promised to arrange a visit for him with his girlfriend if he cooperated. Now this is very fascinating because of all these things right here. I mean, this is interesting to see like what they can get caught up on and what they can't. Hearing these things right here that they've done and whatnot, I mean, think of all these cases that we've watched, these interrogations and whatnot, and you see, if you go into these cases that we watch and you look at it with this frame of mind of like, if you're a layperson like me, you're not part of that world like professionally, watching it is very fascinating because you can start to see the patterns of how these cops get confessions, get information, things of this nature. Now there's some of the times where the cops do stuff that's like, hey, what are you doing? Like this, no, you can't do that. And let's say some of those things you're thinking end up jeopardizing the case or jeopardizing an innocent, like the person was innocent, right? But because the cop was doing whatever. So, you know, I see the need, there has to be a balance is what I'm getting at. But again, seeing these things here that the state's calling out and then looking at the evidence that Sarah has that we know that we see, okay? I'm like, oh girl, no, absolutely not. It's almost like with Sarah, it's like, girl, have you watched the video? You know what I'm saying? They're talking about the judge hasn't seen the interview and whatnot. It's like, Sarah, have you seen it? Are we watching two different things here? I don't know. Let's keep going. It says, and 6, exploited his religious beliefs by relying on a version of the Christian burial interrogation technique, did not render the statement involuntary, though it presented the very outer limit as to what tactics law enforcement may employ when performing a custodial interrogation. 12, although the defendant never states that part of the reason she believes her statement should be suppressed was the minimization of her Miranda warnings, nor cites any case law on the subject, the state infers that she believes this is an issue due to what she has underlined in paragraph 15 on her motion. 13, there are several cases addressing the issue of minimizing the importance of Miranda warnings, and it goes to cite some of these. Number 14, saying this is something I have to do is not minimizing according to Wright, which is analogous, I hope I'm saying that right, to Detective Copsell saying, so I'm going to read you your rights again because we have to talk about that. We just have to do it. They were read in a normal cadence, like in Chafin. There was no delay in reading them. The defendant is not a juvenile, and there is no claim that she is of below average intelligence. I mean, we'll just stay quiet on that. I'm being dramatic. I actually do not think she's a stupid woman at all, okay? I think she's very intelligent and you see what she's done, okay? So a little bit, you know, lacking maybe some common sense, okay, and has some issues going on or whatever, but yeah, I don't think she's not intelligent, okay? She has been read her Miranda warnings just the day before and acknowledged this. It is the defendant who says it is normal protocol. These statements by law enforcement did not render her waiver of Miranda rights involuntary or her statement involuntary under a totality of circumstances analysis. Number 16, in the balance of paragraph 15 of her motion, the defendant outlines the Miranda warnings as they were given to her by Detective Copsell. 17, paragraph 17 through 21 outline what she believes the sheriff's office Miranda card says and how it differs from what she was told by Detective Copsell. 18, interestingly, the defendants believe that this creates some sort of legal impediment to the admissibility of her 2-hour statement that day is not backed up by a single citation to any legal authority within or without the state of Florida's court system. Number 19, instead she makes a boilerplate assertion in paragraph 22 that her statement was involuntary and her waiver of her Miranda rights was involuntary. 20, fortunately for the state of Florida, there's case law on this issue. I like that he or she made it, like number 20. There's a little bit of sass that comes from that state attorney's desk, and I'm here for it, okay? I love it when, and I don't know what you would call if it's like breaking the fourth wall or whatever, and not like when people are completely unprofessional, but when you can tell they're a person too. And I don't know his name right now, but he's one of the state attorneys that gets up there most often and speaks, and he just slides these little quips in along the way. Like when he did the thing about hide and seek, he was like, and then they played hide and seek like we all do, and he just keeps on going. It's like that dry humor, but like dry sassy humor, right? And I am absolutely here for it, okay? It is just pure comedic genius. And I think at this point for him, he's probably like, I have to laugh at aspects of the absurdity or I'll cry my eyes out, okay? So anyways, let's keep going. At 21, it says there's no specific way that Miranda warnings must be given, and with all due respect to the Orange County Sheriff's Office, they certainly do not have the authority to tell this court what sufficient Miranda warnings are. It cites case law. Number 22, while the 4 required warnings have become embedded in police practice, the specific words used vary, and the Supreme Court has not dictated the words in which the essential information must be conveyed. And then it goes on to cite the case law here, and we'll just jump down. And it says the crucial test for determining whether police gave a proper warning is whether the words in the context used, considering the age, background, and intelligence of the individual being interrogated, impart a clear, understandable warning of all of his rights. Now again, without even going back and looking at that damn video, she knew what they were talking about. She got it. She knows what that was. She can come back talking about they forgot to put a period at the end of the last damn sentence, but I mean, she knew, okay? So, end of story, period. Number 23. Detective Copesville specifically instructed the defendant on each of her 4 Miranda rights. Number 1, right to remain silent. Number 2, that anything said can be used against her. Number 3, she had a right to an attorney before and during questioning. And 4, a lawyer could be appointed if she could not afford one. The detective then asked the defendant if she understood these rights, and the defendant said she did. I mean, Kate, can someone slam the damn gavel down, please? Someone slam the damn gavel. We need, we're going to need like a gavel. The mic drop is too, like, not good enough for this, right? We need like a gavel drop, okay? Like a whoosh. Remember having like a Judge Wapner, if you know what I'm talking about? Like, I'm aging myself there. Like, it had like that finality, right? Like one of the OGs of that whole genre. We're gonna need that up in here for the damn sofa. Okay, anyways, let's keep going. Okay, so 24. State versus Owen is directly on point. And then it cites some case law. There, the defendant was read the 4 Miranda rights, asked if he understood them, and asked if anyone had threatened him or promised him anything. There is no mention of any question about whether the defendant wanted to talk to law enforcement after he was given Miranda warnings. This is apparently the Federal Bureau of Investigation's Miranda warnings, which were described as exemplary. I can't say that word, but you see. Cite some case law there. 25. The Miranda decision never contemplated that waiver of counsel could be accomplished only by the use of the words, "I'm willing to answer questions without the service of a lawyer." There is no magic in these words. Any clear and unambiguous conduct by a person who has been advised on his rights, which indicates his willingness to answer questions without a lawyer, is surely sufficient. 26. Therefore, if the court does not strike the defendant's motion to suppress for being legally insufficient, it should deny it on the merits. If the court believes there was a Miranda violation, then the defendant's statements are still available for use during cross-examination. Though, only if the court finds the statements to be involuntary will the state be prohibited from using them in cross-examination. All right, okay, here we go. So that whole thing right there, again, I'm not of that world, right? But just from what we've seen here, it's very obvious. You know what I'm saying? Like, she knew what that meant. She knew what things were being read. She understood that. She went in there, in my opinion, ready to talk. Not maybe to the extent, because remember at certain times she was like, y'all are making me nervous. Y'all are making me nervous. Here's the thing, like I said, Sarah's not dumb, okay? She might not have some common sense, and she might have some issues that like cloud her, you know what I'm saying? Like, way of thinking or whatever, but she's not dumb. When she was in that interview and she starts talking about, y'all are making me nervous, well, you're trying to say this, she's connecting the dots because, in my opinion, she at somewhere within herself knows what she did was wrong, okay? She knows. Anyone could look at that, but she's also probably so narcissistic and so stubborn, she's not going to sit here and even admit to that. Now, again, all that aside, nobody could in this situation, right? Because she's trying to get out of trouble. So no one in this scenario is going to come up and be like, yeah, you know what, I totally, did this on purpose, whatever. It's not going to happen, okay? She's trying to get the best possible outcome. I totally get it. But this whole dynamic of the evidence that they're going to have, I think it's the maintenance man, where she was like, well, I was trying to teach him a lesson and things got out of control. It's just the stuff that came through on the interview itself, on the body cam footage. She knows, at the end of the day, intentional or not, this man died on her watch. Period. End of story. I think that she understands by saying it's not intentional. I didn't mean for that to happen. And I don't think in the beginning she did mean for that to happen, but it transitioned into that. Probably the drunker she got. Because again, if you go back and listen to that video or any of her other body cam footages where the police were involved, I mean, she's like in Never Never Land, okay? It's just like, hello, Sarah, you there? Do you even know what you're saying? I don't think she does. I mean, she goes into this just other world, right? And speaking of other world, let's get to the petty stuff. Okay, so let's get to the glam squad, as I like to call it, right? And just take a minute and go over that. Okay, so on the screen here, you see the first page of the motion. It says defendant's motion for right to hair, cosmetics, and civilian clothing without restraints for trial. Then it just says, comes here, whatever. Let's get down to the statement of facts. Number 1, the defendant is presently incarcerated, is scheduled for trial October 7th, 2024. The defendant has been incarcerated for over 4 years, and defense would like access to professional hairstyling, cosmetics, and civilian clothing without restraints throughout the defendant's trial appearance, and respect for the court and prospective jurors. 3, without the court entering an order permitting her access to such, the right to receive a fair trial will be impermissibly infringed upon. Let's go on to page 2. Let's just make this a little bit larger. So, number 2, legal argument. A, right to appear in civilian clothing. The presumption of innocence is a basic component of the fundamental right to a fair trial. And then it quotes some stuff here. Since the defendant pending and during his trial is still presumed innocent, he is entitled to be brought before the court with the appearance, dignity, and self-respect of a free and innocent man, except as the necessary safety and decorum of the court may otherwise require. He is therefore entitled to wear civilian clothes rather than prison clothing at his trial. Now, to me, that part is pretty standard, and I agree. It's like, yeah, give them their best shot. I mean, no matter what, it's like, that's just fair, you know what I'm saying? Because again, going up to trial wearing stripes or orange suit, I mean, come on, right? However, again, with Sarah, there's just the comedic factor of the glam squad level. I'm thinking Lori Daybell here, like this level or whatever. Very interested to see the look that Sarah pulls off, but let's keep going for now. Number 5 says, here defendant is scheduled for trial October 7th. Defendant will be transported from Orange County Jail daily for her trial proceedings. Defense counsel will be providing the defendant with professional attire for her court appearance. In addition, the defense will need to obtain defendant's measurements. Therefore, defendant requests this court to enter an order placing the Orange County Jail on notice that 1, the defense is permitted to take the defendant's measurements, and 2, the defendant is permitted to dress out in her civilian clothes for her trial proceedings from October 7th to the 25th. Okay, so this right here, and now I've made jokes, I don't know if I've posted them here in live chats or on the Patreon stuff, where we've come up with some looks for Sarah, like some potential outfits, and done some like little mock-ups of them. If you've watched some of the live stuff that we've did, where we were talking about what if the only thing she had to wear was a wedding dress or a ball gown, it was up there. And like one of them we were talking about where the defense was like having to hold like the train to her dress. His thing, he'd have to like hand it to her when he got up to go talk. I cannot. But here's the thing, y'all. That would not surprise me for this case. There's other cases where I'd be like, oh my God, I can't believe, like, seriously? If she walked out, and I'm talking in a full-on Loretta Lynn ball gown on the day 1, I wouldn't blink an eye. I would not. It'd be par for the course, okay? Let's keep going. So it says B, right to appear without physical restraints, and under that, sex. Allowing a defendant to appear before the jury in restraint devices is an inherently prejudicial practice that undermines the presumption of innocence and the right to a fair trial. Generally, a defendant in a criminal trial has the right to appear before the jury free from physical restraints, such as shackles or handcuffs. Again, 100% agree, right? It's whether right, wrong, indifferent, whatever. It gives them the fair trial or fair chance, fair trial, whatever. Also, when you think in the context of no matter how we might feel about the defendant, it's also protecting the law, because you're also having to protect the process, I don't know what you would call it, to basically be like, look, we don't want to be rolling back up in here because they're talking about, we got a conviction, but we're going to overturn it because the jury could see the restraints. You know what I'm saying? Where it's like, I mean, think of Daryl Brooke, right? If he got that overturned because of whatever they had him in. Now, Daryl definitely deserved the shock collar or whatever. And they've talked about Sarah wearing a little shock belt, you know, which we might need to simmer her down from time to time, right? With a little bit of just a little 5 volts here and there, a little bit of a, you know, a Duracell battery volt. That's all. We're not trying to send her to old Sparky yet, right? We're not taking the law in our own hands, but just a little bit, get her attention. Let's keep going. Okay, so number 7, it says September 19th, 2024, the defendant appeared in court bearing handcuffs and shackles. Defendant's hand restraints made it difficult for her to communicate with counsel in written note-taking form. In addition, it is reasonable to assume that the next court hearings will be covered by local and national media, and if the defendant is put on display to prospective jurors in jail garb, they will naturally be led to doubt in her presumption of innocence. Therefore, the defendant is requesting that the hand restraints be removed at all court proceedings from here on out, and that both shackles and handcuffs be removed during trial proceedings. Okay, yes, got it good. Let's keep going. Right to control appearance in courtroom and before the jury. Okay, before I even read this, y'all, like what it sounds to me, if she's talking about I want hair and makeup on standby, can you imagine, like during like motions or whatever, when they would run out like they do on movie sets and stuff, and they're like, I'm gonna be like, what? Are we really living? Like, where are we at? In fact, dude, if you were at this trial and you're here in the comment section, let me know. But anybody who went to Lori Daybell's trial, like her, not Chad, but Lori, number one, the makeup thing. But number two, was she freshening her look up throughout the day? And if so, how did that work? Like, did she pull out some Skittles and said, lick them a little bit and be like, how did it go if she was even allowed to do that? Okay, but now let's see what it says here. So 8, the courts have recognized that a defendant's appearance can significantly impact the juror's perception and consequently the fairness of the trial. In Estelle versus Williams, the U.S. Supreme Court noted that compelling a defendant to stand trial in prison or jail clothing could impair the presumption of innocence, which is fundamental to the adversary system. Now let's jump to 9. Allowing the defendant to present herself in a manner that does not unduly prejudice the jury is essential to ensuring her right to a fair trial and upholding the presumption of innocence. And while the court in Estelle specifically addressed prison attire, the underlying principle applies broadly to any aspect of a defendant's appearance that could influence the jury's perception. Defendant has a right to appear before this court and prospective jurors in the same manner as she would outside of confinement. Cosmetics and hairstyling is standard practice in presenting a professional appearance if the individual so chooses. By extension, incarcerated males are permitted a fresh shave and a haircut. Accordingly, the defendant requests that she be permitted access to cosmetics and hairstyling throughout her trial proceedings, including voir dire. Okay, so that's all the things I wanted to go over. Let's talk about it for a second. Now, yes, again, I agree with the defense on this. And, you know, yeah, they liken it to a dude getting a shave and a fresh haircut, which, as you know, makes a difference or whatever, depending on the dude, right? Okay, but I want to see, again, just on a petty level, we're dying to get to day one to see what she looks like, okay? Period, end of story. I want to see her done up. Now, here's the other thing, before we even get into some of that. Okay, so you know how, like, Ted Bundy, and I always reference Ted Bundy in this because there's so many similarities, where he, like, edged everybody into this false sense of security that he wasn't going to run or do anything. Look at the heinous things that man did. And then he's, like, jumping out of the second story and everything. Imagine if that was Sarah's MO, and, like, day one of the trial, they're talking about inmate escaped. We're looking for a woman about 5'8", full glam, bright purple ball gown, running down the damn road. Can you see her? Damn shackles under the Loretta Lynn ball gown, just running, damn chain over her shoulders. They'd be like, just let her go. I think she's going to damn Starbucks. Just let her get it before we catch her. She ain't gonna make it far. She ain't gonna make it far. Okay, we'll give her a little bit of a 10-volt shock when she gets to the pumpkin spice latte right before the first sip, okay? Overall, one thing that I'm very interested to see with obviously these motions, but this case in general, is the precedent that this this sets. It's so rare that we see cases get dragged out like this and all of this back and forth and all this crazy stuff, right? With the motions and the court and the judges and the lawyers, and all this stuff. So I'm very curious what is going to happen, because my prediction, obviously I'm not there, I don't know the evidence, I'm not on the jury, it hasn't even happened yet, right? But I just don't see how she can get out of this according to what she's trying to say. And so I feel like she'll get a guilty verdict. I feel like they're going to throw the book at her, because obviously, for obvious reasons, multiple reasons. And then I think she'll appeal it, and I think it will continue on. So that procedural aspect to this case, the legal procedures and all that kind of stuff, it's very fascinating to me. And then obviously justice for George in here. There's so many things that go back and forth about, like, oh, they were this, they were that, and I say this in all these videos. And just like the state said, we're aware of the situation between Sarah and George. It was a toxic relationship, right? But no matter what, when that gets to the point that these two were at, where she was willing to let this man succumb to the way he did to the end of his life, that's insane, okay? For her to be able to just walk past that. And then to see that she's sobered up for the 5 years, and just her personality is like worse, okay? It's like not any improvement. I'm just like, oh my God, I didn't think that was possible, but whatever it is. So anyways, by the time you're watching this, it'll be September 30th. We're entering October. Buckle your damn sofa seatbelt, because here we go, okay? I'm going to be streaming the trial as much as I possibly can. I do work, I have a normal job, so just know that I might not be able to do it for 8 hours every day, kind of a thing. But we're gonna be there, okay? To see the case through, justice through, all that stuff. So anyways, if you're still watching, thank you very much. I do ask that you drop some sofas down in the comment section for myself, for Bo, William, and Luke Connor, who are baby and babysat right now, and especially little Rosco in spirit, so we can meander away, hang out, talk about Sarah, all the other cases we do talk about here at the Sofa Squad. And until we do all that, I'll see y'all soon.